So we've had a bunch of white collar cases this season that we've discussed, but we've got a good old fashioned murder case this week. And I'm going to be discussing it with Craig Albee, who's the federal defender in Wisconsin. This case is based on the Gone Girl movie and book that you've probably seen or read, where the woman left a note saying, if I'm found dead, please, my husband is the first suspect. Not a good fact if you're representing the defendant, but you'll hear about Craig fighting hard for his client. He's such a talented lawyer. You'll also hear about how he trains new lawyers at the federal defender's office to try cases like he's done. It's a really fun episode with lots of twists and turns in this murder case. And I'll have an update at the end of the episode about the season, CLE credits, and so on. So I'll catch you at the back end. My name is David Oscar Markus. Welcome back to For the Defense. Next. All right. Well, we're back with For the Defense, and we have a wonderful guest this week, Craig Albee, who is the federal defender out in Wisconsin. And before he was the federal defender out there, he was a private practitioner in criminal defense and handled one of the most interesting cases, the Mark Jensen case, which we'll be discussing. So welcome to the show, Craig.
Thanks, David. Glad to be here.
So a lot of people say that this case, the Jensen case, was the foundation for the Gone Girl movie. We'll get into that, but it's also known in circles as the letter from the grave case.
Yeah. I mean, the big issue in the case, at least at the initial trial, was that Julie Jensen had written a letter that she delivered to the next door neighbor, a sealed envelope, and said, "Give this to the police if something happens to me." She died about 10 days later. They gave the letter to the police, and it said that my first suspect would be my husband if something happened to me. And so that kickstarted the investigation into the case.
Not a great fact to start the case, but it is a weird way to put it, right? My first suspect would be, like, that's a kind of an odd phrasing.
Our position has always been that the letter was a blueprint for framing her husband. She was suffering from serious depression at the time, and was engaging in a lot of bizarre behaviors that I think all could be viewed from a different vantage point than the prosecution did here.
Was there a reason why she would want to frame her husband? Like, what was going on there?
I mean, number one was just the degree of her depression. She had gone to a doctor on her own 2 days before her death. That doctor described her as distraught, depressed, and actually frantic. Diagnosed her with a major depressive disorder and gave her Paxil. Anger at her, she was struggling with her youngest child going to school. So she was alone in home, and her husband was having an affair. Was the other obvious reason for anger towards him.
And she had discovered that.
There's certainly signs that indicate that she had. Yeah.
So this case is all the way back in December of 1998. I saw you came into the case in April of 99 after he was interviewed by police. I guess did he voluntarily submit to an interview for 8 hours?
He did, yeah. So she died in December 98, as you indicated, and then the police asked him to come down to the station in April. He thought he was going to be there such a short time. He even had one of his young sons with him. And then it turned into an eight-hour ordeal. He actually wasn't charged until March of 2002. But yeah, there was an 8-hour interview at that time without a lawyer.
Oh, and when you get the call and you get brought into a great case and you're told, I spoke to the police for 8 hours yesterday. You wanna kill yourself.
Yeah, you generally prefer to get that call before the interview, which of course would never take place in that circumstance. Yeah.
How bad was the interview?
It was read technique on steroids, lots of browbeating, lots of screaming at him, lots of efforts to try to get him to acknowledge some lesser actions of abuse against his wife. He didn't. He agreed that he'd take a polygraph. He didn't say that he had done anything. He just described her situation. Probably the worst outcome from the interview is that it was available in Mark's cell many years later when a jailhouse snitch was able to latch onto it and adopt the theory that the detective was pursuing during the interrogation. And that became the prosecution theory, but it originated with the police officer and then was adopted by the jailhouse snitch.
What was that theory?
So she had antifreeze in her system. Our theory was that she had taken the antifreeze as suicide. Theirs was as a homicide, and that had been their theory for 9 years until the first day of trial. And at that time, it was that he had suffocated her, that he had pushed her head into the pillow. And that theory didn't come up until the redirect of the original medical examiner, who had done nothing other than taken samples and written a basic report about his observations. And on redirect, for the first time, he was shown a picture that showed her nose bent in an unusual position, and then told that this snitch had said that she had been suffocated. At which point, this medical examiner was willing to give the opinion that, oh, this must have been suffocation. It was preposterous, yeah.
So I mean, talking about this medical examiner, I know there's lots of ins and outs with that person. I guess his name was Dr. Long, was the medical examiner, and his first conclusion was that there was more than 20 ounces of antifreeze in her system.
Yeah, a quick step back. The first medical examiner is Dr. Chambliss. Dr. Long is a toxicologist who received the information in St. Louis. So as I said, they didn't charge this case for 3.5 years, and they only did once they had Dr. Long's report. And Dr. Long said that there were 22 ounces of contents in her stomach that was almost all pure antifreeze, ethylene glycol. That turned out to actually be a half a teaspoon of ethylene glycol was in her stomach. I believe he misplaced the decimal point, but it was the entire basis for his scientific conclusion, that this was a homicide.
Amazing. That must have been a fun cross, the decimal point cross.
Absolutely. I mean, for that kind of mistake, with ethylene glycol, it takes about 36 hours for it to become toxic. It's not initially poisonous. It's the metabolites that become poisonous. And so his theory was that if she had that much in her stomach, that wouldn't have been what killed her, and that it was like a second dose that was given to her when she was too weak to have taken it herself. But the entire foundation for that opinion just disappears when you realize it's just a half a teaspoon. It can be left from the initial consumption that she took herself. And the big problem here was that none of this, I mean, the prosecution is pretty shameless. Like, none of it would ever cause them to reconsider what their hypothesis was in the case.
It's crazy, right? So is this a Perry Mason moment where you're able to show that it's much less than the toxicologist said, or had that come out pre-trial?
Our experts had established that, and we had previously cross-examined Dr. Long about it at this unusual thing in this case called a forfeiture hearing that I don't think had ever previously existed. That was as a result of Crawford versus Washington, the confrontation issue.
So it came out. The prosecution knew your position would be it was a small amount of antifreeze, and did they stick to their guns, or did they admit that it was a problem?
They acknowledged that there was the mistake about how much was in the contents. They waffled on what his original opinion was and how much it depended on the contents being all ethylene glycol.
And this toxicologist, I guess, had a history of messing up with antifreeze.
Yeah, so he had testified in one prior antifreeze case in Missouri. Patricia Stallings was a mother of an infant son, and she was convicted of murdering him based on giving him antifreeze, was the theory. And then she gave birth to a second child while she was in jail, and then that child developed the same symptoms as the first one who had passed away. It turned out to be a genetic condition. So Long had been in charge of the toxicology in that case, where an innocent woman had gone to prison. He also, at the behest of the prosecutor in that case, had whited out the spectra so that it matched more clearly for the jury.
Unbelievable that this guy was still allowed to testify. I mean, just shocking.
It really is. Yeah. Yeah.
And I guess when people, non-criminal defense lawyers, listen to these stories, they must think, wow, this is like a 1 in a million shot. What they don't realize is, these kinds of things happen in criminal defense cases all the time. I mean, you're the federal defender now. You see this, maybe not as extreme where a toxicologist put an innocent person away and then, was asked to testify about the same kind of thing again. But we see it every day in our practices.
Yeah, I mean the junk science involved, and he wasn't the only one in this case. The Dr. Chambliss, who I mentioned before, on cross-examination, he didn't know what a microgram was, which is a millionth of a gram, but a basic thing you would understand if you're a forensic pathologist. The next medical examiner was fired because she refused to tell the prosecutor why she wasn't board certified, and wouldn't have been available to testify in the case. So it kind of went on and on.
When you had this case, you were in private practice. Obviously, as a PD, you don't get to pick your cases; you get assigned, and it's one of the actually great things about being a public defender. But in private practice, you get to choose. How did you get involved in this case?
So Mark, after the 8-hour interrogation that we discussed, came to our office in Milwaukee. He was down in Kenosha, which is about 45 minutes away. One of my partners at the time, Jim Shello, is one of the country's great criminal defense lawyers, widely known. He actually came to see Jim initially. Another lawyer, Steve Glynn, and I split off from Jim about a year later, and Mark came with us. And by the time of trial, the case was entirely mine.
I've heard old Jim Shello stories. You have any good ones? Any good Shello stories?
Problem is figuring out which ones I can publicly tell. He was just an absolute genius. Great cross examiner. Just a delight to work with.
Right. Did he have any books or anything that are worth reading? I don't remember.
Yeah, he has a volume on cross examining drug analysts. That was a specialty of his, was cross-examining crime lab analysts of drugs. And for a while he traveled the country explaining that they couldn't prove that the cocaine involved in the case was the type of cocaine prescribed by the federal statutes. That actually caused Congress to change the definition of cocaine, because to prevent that defense any further. Fascinating
stuff. So back to Jensen. So initially, when Jensen's charged and you have the case, you get him a bond, which is pretty rare and unique in a murder case to have a bond. Tell me what happens there.
So I think it was $300,000. His family and friends pitched together to put up the money, and so he was out from within a couple of months of being charged through the trial, or through shortly before the trial in 2007. I mentioned this forfeiture hearing before, which it's complicated. We moved to exclude the letter, and while the motion was pending, we said it was a violation of confrontation. That because we obviously couldn't cross-examine Julie Jensen about her lawyer saying she would suspect her husband. That didn't necessarily go over that well with the prosecutor and some others, the victim rights folks. But The judge agreed with us after Crawford came out, which was during the pendency of the case, which said that we had the right to cross-examine. And the trial court judge excluded the letter. It went to the Wisconsin Supreme Court pre-trial. They said he may have forfeited his confrontation right by killing his wife, but there had to be a determination by the trial judge who had determined by a preponderance of the evidence whether, in fact, he had killed his wife. So we had this unusual situation where we're having a pretrial fact finding by the judge as to whether our client had done this.
So just so everybody's on the same page, the argument is, we can't cross-examine a letter. It's hearsay. It's classic hearsay. There's no person to cross-examine. It's an out-of-court statement offered for the truth of the matter, right? And so you move to exclude it. You say it's hearsay. We have the right to confront the author of the document, of the letter. The judge initially says, agreed, it's out. And then it gets reversed. Is that what happens? The Supreme Court reverses?
They remand that issue because there has to be a determination as to whether there's a factual basis that our client forfeited it by making her unavailable for the trial.
I see. And so at that hearing, the judge, does he consider the letter itself, or is it mostly other evidence?
He does consider the letter and all the other evidence. It was a 2-week hearing.
Wow.
I know in Florida you get depositions. We don't hear anywhere, basically anywhere else. So we had a 2-week hearing before the trial in this case, at which Dr. Long and others testified. So a lot of the case was previewed there,
which is wonderful. Great to have that sort of background and everything else. The problem is the judge ends up taking your guy in after the hearing.
So I guess that was the original question. The very first witness they call was a guy named Ed Klug, who I've been on this case at that point for 8 years, and I started looking through my banker's boxes that are behind me. I've got nothing about Ed Klug anywhere in the file. He had just come forward and claimed that he had a conversation with Mark Jensen a month before his wife's death in St. Louis at a conference, and that he had said he was looking for ways to kill his wife.
There's an expression for that witness in federal court where you get no depots, and you're sitting next to your client, and the government calls a witness, and you ask your client who that witness is, and they say, "Oh shit." That's called the "oh shit" witness when they call him. So Klug gets called and says what? That your client had confessed?
Yeah, at that point it was before her death. So he had said that he was looking for he was researching ways to kill her. After his testimony, the judge on his own, without a motion from the prosecutor, raised bail from $300,000 to $1.2 million, a sum that Mark was never able to meet, and so he ended up locked up from that point forward. And the real sad thing there is that Klug ended up being a highly incredible witness, somebody who's all of his coworkers viewed as an attention getter. Somebody who made a lot of inconsistent statements. He hadn't come forward for a number of years. Changed his story repeatedly. I think if the court had the advantage of knowing all that at the time, the bail never would have been raised because he wasn't dependable enough to rely on.
So I guess two bad things happen at that hearing. One is that the letter is going to come in at the trial because it's deemed forfeit. His confrontation rights are deemed forfeited, and bail's increased. I've always had a problem with bail being denied in these cases, because it's almost impossible to prepare for a trial when your client's detained, especially a murder case like this. To prepare, it's really impossible. It's just a way to squeeze your client, make it more difficult. Make the playing field as we know it's not leveled, but to make it even more unfair. I mean, to have to meet with your client to prepare for a murder trial in custody is impossible.
Yeah, there are a couple things there. I mean, Mark had spent dozens and dozens of hours in our office in Milwaukee getting ready for trial, pouring through enormous amounts of information in the case, and working with us. And now all that has to be done in the jail. He also doesn't have the same access to the paperwork that's in the case, and that there's an enormous amount. And then the other thing that is unfortunately highly predictable in a high profile case like this is when he goes to jail, people are going to be jumping on his case. And that is indeed what happened. Is a number of jailhouse snitches started saying that Mark was confessing to them. Yeah.
So, this happens a lot, obviously, in cases in which our clients are detained. I don't think people realize it, how frequent the jump on phenomenon is, where our system is built on snitching, on people getting their sentences reduced from cooperating, pointing the finger at others, and so on. And so there's a whole culture in the jail. When people in the jail hear someone's going to trial, it's like a party, because people can say, "Oh, he confessed. He told me this. He told me that." And prosecutors really turn a blind eye to this. I mean, what everybody knows are lies.
Yeah, and that's something we really see a lot of in federal court, particularly with the mandatory minimums that exist. Is in many cases, somebody facing trial in federal court, the only way they're getting below a mandatory minimum is to come forward and snitch on somebody. They know that. They start looking for ways to accomplish that in jail. It's a phenomenon that's just much too pervasive.
And of course, in your case, we get a bunch of those. One of them that I saw is a guy named Aaron Dillard. Tell me about this guy who jumps onto the case.
Yeah, so Dillard had many convictions. He had the distinction of being the first American ever to be extradited to Lithuania, where he was selling phony visas to desperate Lithuanians wanting to come to the United States. They'd empty their bank accounts to pay him to get them a visa that was never going to be forthcoming, and that was just pretty emblematic of what his character was. He would defraud anyone at any time. The judge at some point in the trial said that in a third of a century in this business, he was probably the top liar he'd ever had in court. That he said he was on a pedestal all by himself. And that was in response, of course, to denying me the ability to engage in more cross-examination, because he thought that it had already been accomplished. But Dillard, who said that Mark confessed to him, was such an important witness that we had to pull out all stops and do everything we could. Another thing about him is he victimized women frequently, and often would meet them by giving a false name, convince them that he was a home contractor to do work on their house, get thousands of dollars, never do the work. Just a long line of fraud that he had committed.
And so I see you start writing on an easel all the different ways we should call him a liar, con man, criminal, all these things. Do you do that while he's testifying or in closing?
Oh no, while he's testifying, we had the pad of paper out and the marker, and says, and he was freely confessing. I said, "You're a liar. Write down liar, con man, thief." His answer is like, "Sure." He's acknowledging all these things. The other thing we used on the whiteboard with him and other witnesses was to show just how much time they faced upon conviction, or if they didn't have the benefit of the prosecution's recommendation that they were going to be getting in the case.
To show the jury, of course, the motive that they have to come in and just say anything, because if they're looking at 20 years, who wouldn't point the finger at Mark Jensen to get a reduction?
Right. Yeah. I mean, the level of desperation that Dillard and another inmate named David Thompson and others showed. I mean, this was the only way that they were going to get out get out of jail anytime soon was by turning on Mark.
I mean, also what I saw is, trial starts in 2008, 10 years after his wife died. That's a long time between the event and trial.
Yeah, yeah. As I said, the case had gone on, although they didn't charge it for 3.5 years, waiting for Dr. Long, whose opinion was, completely based on his miscalculation. And then we had the Crawford issue that went to the Wisconsin Supreme Court. Then it came back. So all of that, it was a 10-year process.
So you start trial. Where is the trial held? What city?
So we moved to change venue based on all the publicity that been in Kenosha. Um, that was granted, but the court there's an option of going to Madison, Wisconsin, which the court deemed too liberal. And so, in no uncertain terms, that was the reason why I wasn't going to Madison. So it went to a neighboring county, which probably had too high a risk of publicity seeping into the news of that county, but also is a very conservative county, Walworth County in Wisconsin, and a town called Elkhorn is the county seat.
So do you drive in every day or do you stay there?
No, other than at the conclusion of this case, when I heard guilty, the second most depressing words I heard was when I was checking out of the American, and they said that'll be 51 nights.
Oh my God.
I was in the American for 51 nights. Yeah, that was a little brutal.
That's brutal for so many reasons, to be in a hotel for that long, and to people just don't get how this job is, and when you have a long trial like that, what the toll it takes on you.
Yeah, it really does. I mean, a lot of times people talk about the late nights they work. I found myself kind of going in the other direction, as I'd be so exhausted after the day of trial and doing some work that I started going to bed earlier and earlier. But I started getting up at 1 or 2 a.m. to spend 5 hours working before the trial would start for the day.
Oh, I couldn't do that. I don't know how you do that, Craig. That's crazy to me that you would wake up that early and work until the day begins. That's nuts.
Yeah, I mean, it's either work till midnight and get up at 4, or go to bed at 9 and get up at 1 or 2. So I just chose the latter, and for this case.
When you're in trial like that, are you able to do any exercise, eat well, or are you just a mess?
No, pretty much messes. Yeah, I lost about 15 pounds during this trial. The hospital, that courthouse is not near anything other than the hospital. So the lunch option is go to the hospital across the street. You know how hospital food is, so that usually meant pretty much doing without food during the day.
Right. It's second to prison food, I guess. So the trial is televised, which again, I always find interesting. Do you believe trial should be televised? Did it affect the case?
I'll have to say I had a lot greater worries before the case went on about it being televised. The cameras were less obtrusive than, I mean, you really didn't notice them. They had them in boxes and stuff. But there were a lot of ways in which it affected the trial. I think there was some grandstanding by the prosecutor towards the cameras. Certainly, I get a lot more emails when a case is televised from both well-wishers and haters with suggestions about how I should conduct the trial, or just getting out of the business altogether, I guess.
Well, this your judge had another high-profile case televised recently. Same judge as the Rittenhouse case, right?
Yeah, he did the Rittenhouse. I know there was a lot of controversy in Rittenhouse over he refused to allow the people who had been shot to be referred to as victims, which I probably disagree with him in that case, but that came from Jensen too, because Wisconsin allows, like, when witnesses are sequestered, they allow exceptions for victims. So by getting by saying that she wasn't a victim, because that was the issue in the trial, whether it's suicide or homicide. And under our theory, she's not a victim at all. We were able to keep out family members throughout the trial, which was preferable to us, rather than creating sympathy with the jurors for who's attending the trial.
Oh, interesting. So her family members weren't allowed to watch?
I think they were excluded. The ones who were potential witnesses.
Right.
Yeah. Yeah.
Right. The potential witnesses. Sure. Sure. And what about, what I have always found in murder cases, even more so than white collar cases or run of the mill cases, is the decision of the client to testify or not. Because, obviously this is the defense in every murder case is either I didn't do it or I did it, but it was self-defense. It was justified. So either one of those defenses, a lot of times I think it calls for a defendant to testify. Was that a tough decision in your case? And tell me about it.
Very, very difficult decision, because, I think, in many ways, Mark could have told this story better than anyone. A big problem in this case was the admission of very seriously prejudicial information. One part of that, for example, was that 4 years after Julie passed away, they conducted a search warrant at Mark's office around the time when he was first arrested, and there was a collection of penis photos that there was a weak link that the prosecution was trying to make to some harassment of Julie Jensen that had occurred years earlier, where pornographic photos had been left around the house, outside her house. There were things like that were so prejudicial, and I guess on one hand you think they have already come in, but I could just see the cross-examination was going to be just spent on these prejudicial things, probably to the exclusion of the things we most wanted to talk about.
I notice you call her Julie and call him Mark. One of the things that even, all trial lawyers in every case talk about is how to refer to the client in the case. Do you call him Mr. Jensen? Do you call him Mark? How to refer to the supposed victim or, complaining witness in the case? Do you call them by their first name or Mrs. Jensen? All these little tiny decisions go into our work. How did you land on things like that?
Yeah. I agree with your point. I mean, we spent a lot of time worrying about such little things, over and over again. In this case, I mean, what you never call them is defendant and victim. Right. We're all clear on that. Although, there are too many courthouses you walk into and hear that. Part of the, and some judges will only allow you to refer to people by their last names, so you sometimes run into that. I think here the decision may have been less strategic, just in the sense of there are two Jensens, so once you're referring to, rather than refer to Jensen, Mark and Julie seem to be the way to go. It becomes pretty obvious if you're trying to refer to him as Mark and her as Mrs. Jensen that you're trying to dehumanize her at his expense. You certainly don't want to do it the other way around. So here it just seemed Mark and Julie seemed to be the way to go.
Right. And of course the prosecutor always calls them defendant and victim, but you were able to keep out the victim tag.
Yeah.
So the trial takes 7 weeks. Jury goes out. How long is the jury out for?
The jury was out for, I think it was 32 hours.
Oh my goodness. Torture, right?
Absolute torture. The first day, I want to say that closings were done sometime around noon, if I had to guess.
How long did you get for closing?
About 2 hours. Yeah. So the judge, there were a number of alternates, and the judge was concerned that people, given the length of the trial, that deliberations might be a little bit longer, and that somebody wouldn't be available to continue deliberations. And so he wanted an agreement from me that I would allow one of the alternates to just take a juror's place if the juror became unavailable for some reason. And I absolutely wasn't willing to do that. I had no idea, I couldn't predict what the circumstances might be, how far into deliberations it might be. There was no way I was going to do that. So he kept them there, I think, the first day for 13 hours, just trying to insist that so they were there till almost midnight, I think, before they finally begged to go home.
Brutal.
Yeah. And then they continued through, three, into the third day after that, before coming back with a verdict.
So just to back up a second, during your closing, you get 2 hours. Are you a believer in demonstratives and things like this, or are you just talking for 2 hours?
No, I made a point of trying to use, as many demonstratives as possible. These days, I probably would have had more in the way of PowerPoint, although I'm not always a big fan. There it was more, storyboards and things like that. 2008 seems like a long time ago. So, we did use demonstratives.
And at the federal defenders now, do your lawyers use PowerPoint? Is that the main thing they use in their closings?
I think that's right. That would be, or trial, some other variation of PowerPoint, trial director or whatever. Yeah.
Right. It's interesting. In some of the recent mock juries that we've done, some of the jurors' feedback is like they don't really like a lot of PowerPoint, and it's the death by PowerPoint thing. It's unless the slide is really effective. Just putting words on the screen, which you walk into a lot of courtrooms and you see lawyers just putting points 1 through 8 and walking through that. Like, they don't like that.
No, I definitely don't think that's the way to go. It should be used very judiciously, probably mostly for, exhibit, a photograph from the trial, or, something from the scene, or, a piece of evidence. I would agree with that. I mean, putting up text is not generally very persuasive.
Right. So your guy, you get the verdict. You're by yourself. You try the case by yourself, which is really hard to do, a 7-week murder trial. You don't have anybody with you during the trial?
I had my investigator, Angie Kavidra, who was an enormous help. But it was rough, being on all the time, every single witness, no chance that, it's much preferable to have a second attorney there to identify potential errors, get ready for the next legal issue, be taking a witness while you get ready for a more important witness who's coming up later. And I given the length of this trial, I didn't have that available to me.
It's crazy. Do your lawyers at the federal defender's office try cases with each other? Are they on their own?
Yeah, the what we always strive to do, except maybe if it's a very short trial, is to have 2 lawyers at every trial. Yeah.
And how do you train your lawyers to be trial lawyers? I mean, it's so hard these days to get the experience. I mean, being obviously a defender's a great way to do it, but how do they learn how to do the shallow cross and those kinds of things?
Yeah, I mean, you're right. There's a dearth of federal trials, and a lot of times the stakes are so high, in terms of putting somebody out who's inexperienced. The Federal Defender Organization has some, good programs. The Trial Skills week-long program. We try to get, some people to NCDC, or a number of people have been there. And sometimes I've hired people who have years of trial experience already. We work together closely. I guess that's the way I learned too, doing some second sharing, pointing them to the right treatises to, look at, to learn about cross-examination and other trial skills. And, just really work hard to give them the foundation and the work ethic to know how hard you have to work through a trial.
So Jensen gets the bad verdict, but you don't give up. And how do you get to the next stage? Tell us what happens. I mean, it's pretty wild.
Yeah. So I tell Mark that I should not do the appeal. There's one obvious appeal issue, and that is the Wisconsin Supreme Court said the letter comes in if he forfeited his rights, and all they have to do is prove by a preponderance that he caused her absence. 3 months after trial, the United States Supreme Court decides a case called Giles that says you have to show not that just the defendant caused the absence of the witness, but also did so for the purpose of preventing him or her from testifying. So you have to act with that specific purpose. And it was agreed upon even by the state here that their theory was he did it because he wanted, their theory was he wanted to kill her, not because he wanted to keep her from testifying. And so it was clear after Giles that there's no way there should be a forfeiture finding here.
Right.
I didn't do the appeal because I wanted the Mark to have the benefit of somebody else reviewing the transcript and raising any ineffective claims if that's what they thought should be raised. I didn't think that I should be the one reviewing it and deciding whether those had validity or not. So someone else went to the Wisconsin Court of Appeals. The case was lost there. They found it harmless error. And, the hypocrisy of the state to argue harmless error when repeatedly they had talked about this being an essential component of their case, the critical piece of evidence. Every single argument they made during closing was based in some way, it seemed, on the letter itself, and then it's harmless error that it really wasn't that big a deal.
It's crazy, right? I mean, this is the classic example of why harmless error for appellate courts is so result oriented. I mean, so that folks know what harmless error means is that it was wrong to let it in, but it didn't make a difference in the case. It was harmless. And I mean, in this case, to say that a letter from the grave, that Julie's letter saying, suspect my husband is harmless is absurd. I mean, how could a court say that? It makes no sense.
Yeah, and absolutely absurd. And not only that, I mean, at that level, the court had to find that it was harmless beyond a reasonable doubt. Right. I mean, it's like this enormous standard too. But at any rate, so he lost in the Wisconsin Court of Appeals, and roughly at the same time, I joined the federal defender's office. Mark became aware of that. He filed a pro se habeas petition, but asked that I be appointed to take over his federal habeas petition to challenge the state court conviction, which I readily agreed to do. And then so we embarked on that project.
And so, you're now his lawyer again. The appellate court has said they shouldn't have let in the letter, but it didn't make a difference in the trial, so his conviction is affirmed. You're now going into federal court and arguing that it did make a difference. What happens?
Yeah, so we go to the district court, myself, along with Joe Bugney, who's a great federal defender here in the office. And the district court judge agrees that it was harmful error and orders that Jensen be retried. The state appealed to the Seventh Circuit Court of Appeals. They affirmed the district court and ordered a new trial. So all of this took a number of years. I think it was 2015 or 16 before we get the Seventh Circuit agreeing that he gets a new trial.
Well, you were lucky to have Bugney with you. He's awesome, and you guys must have gone crazy and celebrated when you got that order from the Seventh Circuit.
It was a good day. I remember I was meeting with a client in the jail, and he got word while I was in the jail. He was waiting for me outside when I came out of the meeting with the client. So
awesome.
Yeah, that was great.
Awesome. And so now he gets a new trial, but you're at the federal defenders. It's a state court case. You can't keep it.
Yeah, yeah. And so there's going to be more delay because somebody has to digest the 7-week trial as well as all the other discovery in the case and get ready to try this case. So that, of course, takes a long time. The judge refuses to reduce bail. There's now a new circuit court, Wisconsin circuit court judge on the case. And so that takes a whole bunch of time. But then as they approach trial, the state asks that the letter come in to evidence. And they say that the law has changed, that there's been an intervening Supreme Court case that has changed the law on confrontation, and that it no longer should be deemed testimonial, as the Wisconsin Supreme Court had found. And it should be admitted. Yeah, go ahead.
No, what happens? So what happens with that? Does the judge let it in?
Yeah. So the trial court and so the silly thing about that is the United States Supreme Court case had already been decided by the time the Seventh Circuit case was final. So it really shouldn't have been up for reconsideration in any way, shape, or form. The trial court not only says the letter's admissible now, it also says, well, since the letter's coming in, this trial would be just like the last trial, so he doesn't get a new trial.
Oh, geez.
Just absolutely crazy. Bugney and I try to go back to the Seventh Circuit and say they're not following the writ. We lose there in the Seventh Circuit. Meanwhile, the state court, the public defender's office is pursuing appeals of that decision, ultimately resulting in the Wisconsin Supreme Court saying he gets a new trial. The letter's not coming in. It's law of the case. But now Mark has to get a third set of lawyers because his lawyer that was about ready, it was a month from trying the case. His name is Deja Vishny. She retired. So now some new lawyers from the state public defender's office have to start getting up to speed to try the case.
Unbelievable.
And so unfortunately it came, I think it was in January that the case, January of 23, this case finally comes up for retrial. It's 15 years to the month after I tried the case. It's 20, what are we at? I'm trying to do the math. 25 years, is that what it is? After her death. And unfortunately, the jury convicts in this case. And earlier this year, Mark has filed a notice of appeal and is waiting to be appointed counsel on that.
Well, if it gets affirmed, maybe you can do the habeas again and get him trial number 3.
I sure look forward to trial number 3 for him. I would hope that wouldn't take another 15 years. I mean, just the delays in this case were, outrageous, waiting to get that new trial particularly. And again, I mean, the state just, no matter what, never reconsiders, their initial position, no matter how the evidence turns. And one thing I didn't mention is, with Aaron Dillard, the medical examiner at trial ended up relying on Dillard as the basis for her opinion that this was a homicide. She just accepted that. And, I mean, there's some question. I know it, like Illinois, for one, has adopted a statute that keeps out that there's a reliability determination for jailhouse snitches, which is something that should happen. There should be, at some point, somebody like Dillard, who between the first trial and this trial had new fraud convictions. I mean, of course, as you would expect, David, in the first trial, he said, "I'm a new man. Now I tell the truth." By this trial, he's got new convictions showing that was, of course, a lie that we all knew. But whether he should be able to testify at all, or whether there's any scientific, a medical examiner should rely on science, not the statement of a jailhouse snitch. But that's what continued to happen here.
It's wild. Just absolutely wild. Meantime, at your federal defender's office, you have some of the greatest lawyers. We mentioned Bugney, you have Krista Holla, Jess Ettinger. I mean, it's an all-star group over there you have.
We have a tremendous office both in Milwaukee, Madison, and Green Bay. Yeah, extremely lucky to have such a great collection of lawyers here. Yeah,
and this is the kind of case that lots of people obviously watched or interested in. One of the things I saw, and is that his son testified at at least the second trial. Did the kids support dad, or what was the story there?
Yeah, so at the time of her death, the youngest son was 3, but the oldest son, I believe, was eight at the time. So the 3-year-old would have been too young to have any memory, meaningful to testify. And the older son was supportive, and that was one of the tough decisions at the first trial, is whether to call him, because he was supportive. And there was just questions about whether it would be viewed as exploiting him, and some other issues that made that a more difficult decision.
Well, what a fascinating case. I know it's not over yet, even though it's 25 years later. So I just wanted to thank you for coming on the show, Craig, and for your dedication to criminal defense. It's amazing, this story, to hear it.
No, thanks a lot. Love the podcast. Love that you're talking to criminal defense lawyers. It's a great thing. Yeah, thanks a lot.
Keep trying cases.
Will do.
What a crazy, crazy case. You can see why so many books, movies, podcasts have been dedicated to the letter from the grave case. When a woman has a letter saying, "You should suspect my husband," it's just tailor-made for all the crime podcasts and junkies that we have out there. So thank you for listening, and thank you to Craig Albee for being involved. He's a true warrior, defender, and fighter. We have another great defender here in Miami, Michael Caruso, and this episode is dedicated to all the assistant federal defenders and defenders who are out there fighting for their clients, state public defenders as well. They are in our courts every day fighting for clients, and oftentimes not recognized as they should. They're some of the best lawyers in our country. We have one more episode that we're going to have in this podcast season. It's going to be Margot Moss, my partner, and I discussing the Andrew Gillum case. And I will have CLE credit codes for Florida at the end of that episode. I'm also planning a couple bonus episodes coming up, which should be really fun. And I'm looking forward to it. So thank you so much again for listening. Please share, please comment and like. It really helps spread the word. My name is David Oscar Markus, and I appreciate all of you for listening. Thank you.